Karen Read's trial is set to begin tomorrow, Tuesday, April 16th, with jury selection. We'll see how long jury selection process takes, but once the jury selection process is concluded, then the trial is expected to take somewhere between 6 and 7 weeks long. So about 4 weeks for the state's case, and then another additional 2 weeks for Karen Read's case. So before trial, there's always a hearing on the motion in limines that were filed. A motion in limine is simply a motion that either side can file asking the judge to either not allow certain evidence or testimony in during the trial, or to specifically allow certain testimony or evidence to come in during trial. So, for example, let's say you have certain evidence that you want to come in during trial, and you're not sure whether the other side is going to object, and it can completely throw off all of your planning and your theme of the case. You want to have a ruling on that before, so that you can start preparing effectively for trial. So that would be one reason to file a motion in limine, that you specifically want certain evidence in. And then also, you also specifically want, if you're thinking that the defense or the state is going to introduce certain evidence that you don't like, and that's what you're anticipating, and you want to right away ask the court to not allow that to happen and not be surprised with it during trial. So that's another reason to file a motion in limine, that you do not want specific evidence allowed in. So there was a hearing. There was about 30 different motion in limines that were filed. We're going to be discussing some of them, which I found interesting. And of course, we're going to get to the main one, which probably most other people are talking about, the ones that are the most important ones, probably, that has to do with this case. But as you know, trials can sometimes be won with this small little detail. So some of these small little motions that no one's talking about could actually play a very big role in the Karen Read outcome, and the outcome for Karen Read during this trial. So we'll be discussing some of the smaller, less exciting motions in limine, but we're also going to get into the big hot topic ones near the end. So let's go through one at a time. So we had a motion in limine to exclude certain DNA, and apparently there's still some testing going on with certain DNA. I believe it's from a hair that was found on the tail light from Karen Read's car. As we know, the allegations here by the state is that she backed her car into John O'Keefe and then left him to die in the cold. Well, there's some here that apparently they're testing a DNA, and they haven't gotten back the results yet. And the defense is arguing that this is trial by surprise. We need to know what the DNA results show so that we can counteract that with our defense. So that was one issue. And most of these, the judge said that she is not going to rule on, or she's taking under advisement. I believe that most of these issues are still under advisement, and it could be by the time this video comes out, she's already have made a ruling about it, but I don't know if she has. Please let me know in the comments, and that we can all be informed. But as the recording of this video, I do not know that she's made any rulings about a lot of these issues. All right, so that was number one. Number two is that there's actually going to be a little field trip for the jury. They're going to have a field trip down to 34 Fairview Road. That is where John O'Keefe's body was found, and they're going to have a little view of where everything happened. Now, there's also a motion in limine regarding the Aruba incident. There was a fight disagreement between Karen Read and John O'Keefe in Aruba, and this was December 31st, 2021, which is about a year before John O'Keefe was found dead. So the argument here is that this is a year before. Why should evidence come in? Every relationship has some ups, has some downs, has some disagreements, and why should, just because they were in a disagreement a year before, have anything to do to show that why Karen Read would carry out this murder? So that was the defense's position. The state's position back was, well, this was just the beginning of a dispute, but we were going to be able to show through text messages, other communications, voicemails, that this dispute continued and it turned the relationship toxic, which very likely, according to the state, led to Karen Read carrying out this murder. Now, they discussed also evidence of Turtle Boy's harassment, his charges, his harassment of witnesses, and they both said, the state and the defense for Karen Read said, that they have no intention of introducing any sort of evidence that have anything to do with Turtle Boy, whether he was harassing witnesses or not, whether he was charged with anything. They both have no plans of doing that. So they both essentially asked the judge, why do we even have to talk about this or even make a ruling about it? And the judge very smartly said, well, just because you're not anticipating it, it doesn't mean that a witness is not going to answer one of your questions using that as a reason, using a reason that, well, they felt harassed by Turtle Boy or something like that. And then what are we supposed to do with it at that point? It's better to be prepared to know what to do with that type of answer before trial happens. So that was the judge's response, and therefore she's going to have to figure out whether any of that is going to be allowed in. It could be the natural answer to the question that the witness has asked, and therefore it's important to know what to do before they're sitting in front of a jury. Now, there's also some interesting argument here made about the blood alcohol testing that was done on Karen Reed. Now, we know that Karen Reed was drinking that night, and she was at a number of, at least one bar, and she had a high blood alcohol content. Her blood had a high alcohol content in it. So the question is that whether that medical record showing what her blood alcohol content levels were, whether that's going to be admissible or not. And what really this comes down to is the following. Medical records are generally speaking admissible because they are an exception to the hearsay rule, right? Everybody knows the hearsay rule. So this should be straight out hearsay because it's an out-of-court statement or document or writing. So it's all considered hearsay. And why in the world should it come in? It wasn't under oath. There was no one that was able to cross-examine. I mean, there's a lot of problems with it. So why should a medical record be allowed in? And the answer to that is because it's a hearsay exception. Certain records have more of a reliability on it. And that is that generally speaking, people are more honest and truthful when they're talking to a medical professional about some sort of sickness that they have. Or if you go into a medical facility, they generally follow a certain practice and their reports are accurate. There's no reason why they would lie about a medical record. Whereas if you're not in the medical setting, you're not in the doctor's office, you're just on the street talking casually, so then those statements, people lie all the time. But in the medical field, people don't lie. You're not supposed to lie, so therefore there's an additional level of the statement being truthful. So therefore, generally speaking, medical records are admissible and they're not a hearsay problem. So what should be the problem here? Why should there even be an argument that her blood levels should not be allowed in as part of the medical record? It's part of the medical record after all. Well, the argument here was interesting. The argument that the Karen Reed's defense attorney made was that this was not a statement made in the furtherance of a medical diagnosis or treatment. And this was not even a treatment that the medical facility was going to check her for. This was actually at the request, and this is what the argument was, that this test specifically was done at the request of the police department. So generally speaking, when you're treating a patient, you're using your medical knowledge and training and experience to treat a person. But if somebody else injects an idea into your head, oh, maybe you should test for that, maybe you should test for this and the other thing, well, then that reason why that person is doing it is so that they can charge her. So therefore, the argument is that this was not a statement. This was not a medical record that was just created in the course of treatment or diagnosis. This was really at the request of the police station, and therefore it should be considered hearsay. So that was the argument that Karen Reed's defense made regarding that. Also, another problem here is that the range for how off the blood alcohol content was very extreme. It wasn't like within a few points of each other. It was either like something like 0.13 to 0.23 or something. So off when it comes to blood alcohol levels that obviously it also shows that the test is not reliable. And again, the whole reason why a medical record is allowed in is because it's more reliable than a regular out-of-court statement. And here you see that the test itself is letting us know that the range here is so wild, such a big range that it questions the reliability of the test, and therefore it should also not come in and it should be considered hearsay. So that was another argument that was made. Also, another interesting argument was with respect to the manner of death, and that is that the defense attorneys, the defense for Karen Reed is going to have an expert say that the cause of death for John O'Keefe is undetermined. And when that's called the manner of death, right? Generally speaking, the medical examiner will give a cause of death, which is what sickness did the person actually die from, or as well as provide manner of death. Manner of death is, was this an accident? Was this a suicide? Was this a homicide? Or was this undetermined? And they have an expert, the defense has an expert to say that the manner of death here is actually undetermined. Now, if that's true, if it's undetermined, well then the state was arguing that really the manner of death should not be allowed in. And the reason for that is that they argue that this is an ultimate question for the jury to make. The jury has to make certain ultimate questions. This is what we refer to as the ultimate question. The jury is going to decide whether there was a homicide here, and the jury is going to decide who committed the homicide. These are ultimate questions. So generally speaking, to get a witness on the stand to answer an ultimate question is generally not allowed. Now, there are exceptions to this, like certain experts and things like that, but we're not going to get into that. But I'm just going to tell you what the argument was. The argument here was that since the manner of death, which is either a homicide or a suicide or an accident, is one of the ultimate questions that the jury has to decide, the manner of death should be stricken and should not be allowed in. Now, the argument back from the defense, from Karen Reed's team, was that actually, even though this is the manner of death, generally speaking, could be in answering an ultimate question, but over here, when the manner of death is undetermined, when it's undetermined, that's not answering a question. It's just saying it's undetermined. So if the manner of death would be homicide or accident, so then you're telling the jury what you believe this manner of death was. But if you're saying that it's undetermined, well, then you're allowing the jury to determine the fact. Now, part of the argument back could be is, well, you're telling the jury that it's undetermined, so they're going to be undetermined. Okay, so, but these are some of the arguments that were also made regarding the manner of death. Now, another interesting part was whether leading questions should be allowed for a child. When you have a child witness, now, generally speaking, obviously, leading questions are not allowed when it's the direct, under direct testimony. So if you call a witness, so under direct, it's your witness, you're not allowed to lead the witness to give, basically you're leading them to give, you're suggesting an answer. Cross-examination, you are allowed to lead. That's the whole art of cross-examination. But if it's your witness and the witness is supposed to be helping your case, so then you're only allowed to ask open-ended questions. You're not allowed to suggest an answer. But when it comes to a child, so then it can be confusing and hard for a child to understand what type of information you're trying to elicit from them by asking open-ended questions. And therefore, the argument here was that they should be allowed certain leeway when it comes to leading questions for child witnesses. All right. Now, there's also an issue about body cam footage. There was certain body cam footage that Karen Reed was when she was being booked, and certain statements that she made, and the state wants it in because she gave varying accounts of what happened that night. So if it was always, I'm innocent, I have no idea what happened, and it's very simple, I just went home that night and went to sleep, and I have no idea what happened to John O'Keefe, well then, how come you're giving so many different stories to the police? So the state wants that in for this certain body cam footage, and the defense doesn't. And the defense, part of the reason why the defense doesn't want it in is because that you're going to see Karen Reed in handcuffs. And for the jury can't unsee that. The same way that a defendant is not required to show up in a orange jumpsuit in front of the jury during the trial, because you don't want to paint the defendant as already guilty, because the defendant is always presumed innocent. So too, the defense doesn't want the jury to see her in handcuffs. That will already make an impression on them that she's guilty. So that's another reason why they don't want this body cam footage in it. The entire body cam footage is about an hour long, and the judge wanted to review the entire hour-long footage before making a determination about whether she's going to allow that in. All right, there's another issue that came up was with respect to whether there can be any references to the investigation, the federal investigation that is being done into the Boston Police Department. So can you talk about the federal grand jury proceedings? Can you talk about that? And the difference is actually very subtle but very important, because when you have the defense for Karen Reed, they're going to want the jury to know that there's a federal investigation here. They're going to want to know that. And therefore, they're going to want to ask questions the following. So, officer, whoever is on the stand, Officer Proctor, whatever, Trooper Proctor, when you were being asked by the federal grand jury, when they were investigating the Boston Police Department here for corruption, did you say, the following things? Now, obviously, once the jury hears that, That's exactly what you want from the defense attorney, right? But the state doesn't want that in. The state just wants that if you're going to reference a certain statement that any of these witnesses made during any of these federal investigations, you shouldn't be allowed to talk about the fact that there is a federal investigation. Just say that this was a statement that you gave under oath, correct? It was in a different proceeding, maybe you can say, but you should not be allowed to say that there is a federal investigation ongoing, or that you gave this and in the course of a federal investigation. Anything to do with that, they don't want in. And it's going to make a very big difference. So this is also another point, which is a very big difference. The judge has to make a determination about that. Also, the internal affairs investigation, they don't want any of that information in. Okay, so that really takes care of a lot of the, I think, interesting also issues when it comes to rules of evidence and case law and things that can be researched. That's interesting in its own right. But then it comes down to the two, I think, probably most important parts of this case. And it has to do with the defense themes in this case. And it really comes down to two specific rules of evidence from the Massachusetts Rules of Evidence. One of them is Section 1105, and one of them is Section 1107. We're going to talk about 1107 first. So 1105 is simply the third party culprit evidence. And that is when you want to point the finger at somebody else. So you want to make the argument to the jury. If you're the defense, so let's say in this case, Karen Reed, you're the defense in this case, you want to be able to tell the jury, Karen Reed didn't do this murder. It was actually Brian Higgins. That's called a third party culprit defense. Now, there's also a different defense, which we hear a lot about. In almost every criminal trial, we always hear about this other type of defense. And that's Section 1107 in the Massachusetts Rules of Evidence. And that is the inadequate police investigation evidence. So you want to introduce evidence to show that the police did an inadequate job of investigating this case. And this is always something that we always hear. The police did not do a full investigation. They concentrated on my client. If they would have done a complete investigation, a full investigation, if they would have followed all of their leads, then they would have found 20 other people that they could have indicted. But they didn't, because they found my client, and that's it. They wanted my client. My client fit enough of the bullet points, and therefore they just wanted to have an easy job, and that's what they did. So this is what we hear a lot about. So specifically when it comes to the Rules of Evidence in Massachusetts, let's discuss the inadequate police investigation evidence. So the rule is pretty short. The rule says the following: admissibility. Evidence that certain tests were not conducted, that certain police procedures were not followed, or that certain information known to the police about another suspect was not investigated, in circumstances in which it was reasonable to expect that the police should have conducted such tests, followed such procedures, or investigated such information, is admissible. So this evidence that these tests should have been conducted, or that there are certain police procedures, there are certain policies, right, that police have, and you're able to show that they didn't follow those policies, or that there was certain information that the police knew about, or another suspect that they knew about that they did not follow up on, that is admissible. That's the rule. Now, this is what is referred to as Bowden evidence, or a Bowden defense. All right, so if you were listening to the motion in limine hearing, and it was a little long, pretty long, and you got to the end of it, and they started talking about Bowden, and the judge was talking about Bowden, and the defense was saying a Bowden defense, and the state was saying Bowden defense, and you may be watching this scratching your head. What in the world are they talking about? Well, this is what they're talking about. A Bowden defense is simply, or Bowden evidence is simply evidence that the police investigation was inadequate. It's referred to as Bowden evidence and Bowden defense. Now, there's a number of case law that number of opinions that came out in the Massachusetts case law that talks and explains certain things about the Bowden evidence. All right. So the first thing is that the judge has to make a determination that the evidence is relevant. That's number one. So once the judge does make a determination that the evidence is relevant, what comes next? Well, the case law said the following: once determined to be relevant, Bowden evidence is admissible unless its probative value is substantially outweighed by its prejudicial effect. And this is something that I've spoken about previously, surprise, surprise, but it's still a very important part. And that is that any time that you want certain evidence not admitted in trial, and you're running out of reasons why it should not be allowed. You ran out of it. You tried hearsay, it doesn't work. You tried authentication, it didn't work. You tried character evidence, it didn't work. You tried prior bad acts. You tried all of these ways to get this evidence out, and the judge is not buying any of it. The last one that everybody hangs their hat on is that the prejudicial effect on the jury substantially outweighs the probative value. And the way that that works is the following. We start off with, is this evidence relevant? Is the evidence relevant? And it's very, very broad. All rules of evidence are very broad when it comes to whether something is considered relevant. Relevant can be something this victim and defendant were in an argument 15 years ago. Sure, that's relevant. It does have some tendency to show that maybe that's why the defendant committed the murder. So relevant is very, very open and broad. But the next step is that once you determine that it's relevant, well, is this information going to be such a tremendous prejudice on the jury that once they hear this information, they're going to completely be prejudiced and not be able to make a determination based on the facts and the evidence of this case? So then the argument could be that it still should not come in. Even though the evidence is relevant, it still should not come in. So this is the two steps that the judge has to make when it comes to Bowden evidence. Once the court determines that it is relevant, the next step is this information so prejudiced on the jury that the jury's not going to be able to make a determination anymore based on the facts and the evidence. It's too prejudicial on the jury. Now, of course, most evidence is prejudicial in one way or the other. It proves one side's case or the other. But this is just overly prejudicial, right? It's substantially prejudicial. All right, so that is another thing. Now, there's something also that the courts stress here, which is actually like a tip to the defendant. And that is that you have to understand that when you go down the route of a Bowden defense or offering Bowden evidence, you have to understand that it's a double-edged sword. And the courts actually speak this out. Because once you open the door as to why the police did not investigate a certain lead, then the state is able to respond and explain why they didn't go follow a certain lead, and that may be very damaging to your case. So you should be very careful about whether you want to open the door. And this is something that we find it's a strategic decision, and you should not make this decision on the fly. All right. Now, let me give you a perfect example of this exact issue coming up. So if anyone was following the Jennifer Crumbley case and you followed the trial, so Jennifer Crumbley was charged. She was the mother of the Oxford high school shooter, and she was charged with involuntary manslaughter for the students that her son murdered. And she was married to a man named James Crumbley. They were both charged. Eventually, they were both convicted. But during Jennifer Crumbley's trial, it was a very interesting point at one point. And what came out was the following. Jennifer Crumbley's attorney filed a motion in limine to keep out any evidence that Jennifer Crumbley was engaged in an affair. And Jennifer Crumbley did have an affair right around the time that her son became the shooter. So part of the reason why the state would want that in is because they want to show that she was more concentrated on her own enjoyments in life than parenting her child and making sure that her child's not getting his hands on a gun and making sure that the child has the proper mental professional's intervention. So she was in the middle of an affair, and the defense attorney filed a motion to keep any remarks about that affair out of trial, which was a good move. You don't want the jury to hear that your client was involved in an affair right before their son carried out a murder. Doesn't really look good, right? So the judge granted that motion. Now, during the trial, the state called the person who Jennifer Crumbley was having an affair with. And he got on the stand. Now, he was talking about something else because they were also friends, and they were talking about, certain interactions that he had or she had with her son. And during the cross-examination, the defense attorney was trying to make a point that the police were not using the appropriate means in their questioning to this witness on the stand. Now, again, in the back of everyone's mind, the jury doesn't know this. doesn't know this. But in the back of the defense attorney's mind and the prosecutor's mind, they know that this is the person who was having an affair with Jennifer Crumbley. And some of the questions that the defense attorney was asking was showing and implicating how the police were threatening him and pressuring him to give certain answers and things like that. So to show the police were not doing their job. Now, the problem with that is that once she's starting to show that, well, the state wants to be able to counteract that. And the way to counteract that is to say, well, the reason that he wasn't being so forthcoming is because he was involved in the affair. So if she's going to open the door to this line of questioning and show that the police weren't acting appropriately with him during their interview with him, then the state should be allowed to also talk about the affair. So this is exactly the type of scenario where if you go down this route, if you open the door as a defense attorney, then they can bring out this other information, which can be very damaging for your client. Now, in that specific case, Jennifer Crumbley's attorney decided that even though she filed a motion in limine to not allow this in, she still said, no, I want to fully cross-examine this witness, and therefore go ahead. We're going to talk about the affair also. And that's what happened in that case. But that's the example of when you start challenging a police investigation, that the state is going to be allowed to rebut your suggestions and explain why they didn't follow certain leads, things like that. So you got to be careful when you use this. Now, here's another part that comes up when you're arguing that the police investigation was inadequate. Another part is that how is the police getting their information? Most of the way that the police gets their information is through hearsay, right? I mean, they do get some information from witnesses, from eyewitnesses, but they also get tips and writings and statements that are complete hearsay. So then you can be wondering to yourself, well, why should any of that hearsay be admitted? You're trying to show that the police did not investigate. Let's say they got called with 25 different leads. 25 different random people called the police station and said, we know you're investigating the certain murder of this person, and we have a lead for you. And you want to show as the defense attorney, well, did you follow up on those leads? No, you didn't. You didn't follow up on those 25 leads. As soon as you found my client, you charged them, and you're pinning everything on my client. Why didn't you follow up those leads? Well, how are you supposed to get those leads into evidence? Those leads are straight out hearsay. How do you get them in? So here, the courts explained how you get this in. They did a job. They did a help for the defense attorney in case the defense attorney can't think about this themselves. So they helped out the defense attorney here saying, how would you get this information in? The way that you get this information is that you always have to go back to the basics, is what we always do in this channel. Let's try to understand everything in its basic level, and then we can understand how certain pieces of evidence can get in, even though despite there being a rule of hearsay. So hearsay is, again, clearly the rule is that an out of court statement is not allowed to be admitted for what purpose? What purpose is the statement not allowed to be admitted into evidence? It's not allowed to be admitted into evidence to show the truth of the matter asserted in the statement. So, for example, you want to introduce a statement that somebody made outside of court saying he's going to go to Burger King this morning for breakfast. And the reason why you're introducing that statement is because you want to show that he actually did go to Burger King that morning for breakfast. So that means, what's his statement? I'm going to Burger King. You're trying to prove that he went to Burger King by his statement. That is straight out hearsay. But let's say you want to introduce the statement to show that he was hungry that morning, not to show that he actually went to Burger King, but you want to show that his state of mind was that he's hungry, or that his state was that he's hungry. So then you're not offering the statement for the truth of the matter asserted. You're just bringing it to show what his state of mind is, what his state of hunger was. So then you should be allowed to admit it. So too over here, they're arguing, the state tells you that, the case law tells you that the reason why you're allowed to introduce these tips is because it's not to tell you that the truth is in the tips. The information is to show you that the information was provided to the police. And what actions did the police take based on that information? This is also something that's you find a lot. The police a lot of times are talking about certain tips that they gave or certain information that they discovered, and you always have objections from the defense. Oh, it's hearsay. And the response to that is, no, we just want to show you why the police took certain action or didn't take certain action. So same thing. The defense attorney is in this situation. If you got 25 tips, we don't care what the actual statements in the tips were to prove any matter asserted in the statements. We just want to show that this statement was made to a police and they did nothing. That's what they're being introduced to show, and that's why it's not a problem of hearsay. All right, so that's when it comes to why that's allowed in. Now, there's also another part when it comes to the difference between third-party culprit evidence and Bowden evidence. And listen to this. We're going to get to third-party culprit evidence in 1 minute. But just to fully explain the inadequate police investigation evidence, let's just take it a little bit further. Third-party culprit evidence may be admitted regardless of whether the police knew of the third party. Okay, so you want to introduce third-party culprit evidence, which means it wasn't Karen Reed that did this murder. Let's just say it was Brian Higgins, right? You want to show that it was Brian Higgins. Now, let's say that the police had no idea who Brian Higgins was. They didn't know anything about Brian Higgins. And you, as the defense attorney, are going to introduce evidence who Brian Higgins was, what his intent was, what his motive was, what his opportunity was. You're going to introduce all of that good stuff, and the police never even heard of him. That's fine. But what about when it comes to inadequate police investigation? So the courts say, the Massachusetts courts, they say no. It says, whereas Bowden evidence is relevant only if the police had learned of the information during the investigation and failed to reasonably act upon it. Because again, here the point is that they had information, they had some tips, they had some reason to investigate further, and they didn't. So you have to prove, number one, that the police had certain information that could have been followed, and they chose not to follow that information. Whereas third-party culprit evidence is, no, the police didn't have to know anything about this, and still we can prove to you that it was somebody else that had opportunity and motive and intent to commit this murder. Now, because of that, the judge has to conduct a voir dire hearing because she has to determine whether this Bowden evidence has been furnished to the police. Did the police get this information or not? So she has to hold a hearing before the jury hears anything about it. She has to first make a determination. Did the police have any sort of information about some leads that they could have followed up on that they didn't? So that's also something. And then they also obviously she has to make the determination whether probative value of the Bowden evidence is substantially outweighed by the risk of unfair prejudice, which we discussed already a little bit earlier in this video. Finally, one last point. And now, once we understand this is going to make third-party culprit evidence very understandable as well. And that's why when you, because you're a viewer of my channel, are following this trial, you're going to understand everything that's going on much clearer than if you wouldn't know anything about the difference between Bowden evidence and the third-party culprit evidence. So one last thing is that unlike third-party culprit evidence, there is no constitutional right to present a Bowden defense. And we're going to talk about this in a minute when we get to third-party culprit evidence. Third-party culprit evidence is a constitutional right to provide that defense. There's no constitutional right to provide a defense, a Bowden defense, that the police investigation was inadequate. And therefore what? And therefore the following, which is a very, very important part that no one else is going to understand except you, my viewer of this channel. Therefore the following. When a judge makes a ruling in a trial, then let's say that the defense they lose the trial and they want to appeal the case. So you appeal everything, all the decisions that the judge ever made. When the Court of Appeals gets the record and they get the rulings that the judge made, the Court of Appeals has to decide, well, did the judge make the right determination here or wrong, right? Did they make the right one, the right decision here, or was this decision here not the right decision that she made? But it's not enough just to show, she made the wrong decision. And therefore, anytime that a judge makes any sort of wrong decision, we're going to reverse the case and order a new trial. That's not the way it works. It depends on what issue she made the wrong decision on. And when it comes to the admission of evidence, generally speaking, and when it comes to, and certainly when it comes to the police inadequate investigation evidence, it's reviewed on a very high standard, which is called an abuse of discretion. So the judge has very wide discretion about what evidence can come in and what evidence cannot come in. And even if the Court of Appeals decides, you should have let this evidence in, or you should not have let this evidence in, but still, was it an abuse of discretion for it to allow it in? Did she have any sort of reason, or was there any sort of basis to allow this evidence in? Even if she was wrong, but if there was some sort of basis, some sort of reason for her to allow this evidence in, then they're not going to order a new trial. They're not going to reverse the Court of Appeal, the trial judge's decision. So that's when it comes to inadequate police investigation evidence. If this judge decides that certain evidence does not come in, the only way to reverse her is to show that it was an abuse of discretion, which is a very, very high burden. And that's not the case when it comes to the third-party culprit evidence. So therefore, when you're sitting in your chairs and you're thinking, that judge just made a wrong ruling, but then you're going to have to question yourself, wait, was this part of the third-party culprit evidence, or was this part of the Bowden evidence? And if it's part of the Bowden evidence, then it's an abuse of discretion standard, and it's probably not going to be reversed. But when it comes to third-party culprit evidence, then we're going to see it's a much lower burden for the Court of Appeals to reverse a trial court's determination. So now that we've kind of set the stage for the third-party culprit evidence, let's talk about the third-party culprit evidence rule. So here's what the rule says. This is section 1105. Evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible, provided that the evidence has substantial probative value. In making this determination, the court must make a preliminary finding that the evidence is relevant, is not too remote or speculative, and will not tend to prejudice or confuse the jury. So, for example, let's take a simple example. You want to provide evidence. Let's say in this case, Karen Reed. You want to provide evidence that John O'Keefe was in a fight with his neighbor 25 years ago. And the neighbor threatened him. But that was 25 years ago. It's too speculative. It's too remote. That's not going to be enough. The judge should not allow that evidence in to show that there is a possible third-party culprit here. It has to be much more relevant than that. All right. So there's some case law on this that's also important to know about the third-party culprit evidence. So the following. Third-party culprit evidence that someone else committed the crime charged or had the motive, intent, and opportunity to do so, is a time-honored method of defending against a criminal charge. A defendant possesses, and listen to this is so important, a defendant possesses a fundamental due process right to present such evidence. You have a due process right. This is a right that you were given in the Constitution to present a third-party culprit evidence. And listen to this. And therefore, let's say the judge has a doubt. The judge is on the fence. She's not sure whether certain evidence should be admitted as a third-party culprit evidence. She's on the fence. So what should she do? So the case law is instructive. And the case law tells you, Massachusetts, doubts about admissibility should be resolved in the defendant's favor because we're dealing with a constitutional right. So therefore, the doubts about admissibility should be resolved in the defendant's favor. And now listen to this. Because the issue implicates constitutional rights, appellate courts review the decision to exclude third-party culprit evidence independently, rather than for abuse of discretion. Now, normally speaking, like we spoke before, usually the admission of evidence, whether the judge made a wrong decision or not, is reviewed for an abuse of discretion. Did the judge abuse her discretion by allowing this evidence in or by not allowing this evidence in? If she did, then you reverse and you order a new trial. But when it comes to third-party culprit evidence, then listen to what the burden is. And the erroneous exclusion of such evidence upon proper objection requires reversal unless harmless beyond a reasonable doubt. So the only way you don't get a reversal is if it's proved harmless beyond a reasonable doubt. It's like the complete opposite side of the spectrum. If it was harmful at all, if you can prove that this evidence, by not allowing it in, was harmful against the defendant, and you only have to prove it by the only way to disprove it is to prove that it was harmless beyond a reasonable doubt. So if there's any indication that it was harmful, then it automatically gets a reversal. That's how easy it is to reverse this type of decision to exclude evidence of third party culprit. Now, just a few more points about it, and then we'll wrap it up. While defendants are entitled to wide latitude in introducing third-party culprit evidence, the evidence must be relevant. That is, it must have a rational tendency to prove the issue raised by the defense and cannot be too remote or speculative, which we spoke about. Now, here's also one more very important part. Maybe a few more parts. Evidence of a third party's ill will or possible motive to commit the charged crime standing alone is insufficient to qualify as third-party culprit evidence. So ill will. Let's say you're able to prove that John O'Keefe and this other guy had ill will toward each other. They were enemies. They did not like each other. And therefore, that was a possible motive. That alone is not enough. That's not enough to be considered third-party culprit evidence. The evidence must also show that the alleged third-party culprit had the intent and opportunity to commit the crime. So if you can show that John O'Keefe had this enemy who lived in California, they really, really did not like each other. But for all intents and purposes, that's it. You don't see that he had any opportunity to kill John O'Keefe, and you don't see that he had any intent to kill John O'Keefe. Then the fact that they had ill will and the fact that they were in a huge fight a day before John O'Keefe's murder, that's not enough. That's not enough to allow in evidence that they actually had ill will towards each other. So you have to have all these three things. You have to have motive, intent, and opportunity. Now, remember we spoke about hearsay when it comes to inadequate police investigation evidence. And we said that certain hearsay is allowed in because it's not being offered for the truth of the matter asserted. But listen to this. In rare circumstances, the defendant's constitutional right to present a defense may require the admission of otherwise inadmissible hearsay evidence to establish a third-party culprit defense. So now when we're watching this trial, and it could be that we're going to hear some statements of hearsay, and all of the legal scholars out there are going to be wondering, hey, isn't that hearsay? Why is the judge allowing that in? Well, if it's evidence of a third-party culprit, then it could be allowed in. And that's maybe why we're hearing it. But such evidence is admissible only if, in the judge's discretion, the evidence is otherwise relevant, will not tend to prejudice or confuse the jury, and there are other substantial connecting links to the crime, which I think is the most important part. If there's other substantial connecting links to the crime, and then you also have some hearsay statements. So you have 15 other things that connect, let's say, Brian Higgins to John O'Keefe. And then you also have a few hearsay statements. So then that would be a reason why to allow in the hearsay statements, because really it's so much other evidence that you also have at the same time. If all you have is the hearsay statements, so then that would be a problem. If it's just to corroborate, then it should be allowed in. Okay, so that's really when it comes to the third-party culprit evidence and when it comes to an inadequate police investigation. So now we can understand really much more. If you go back and watch the hearing on the motion to eliminate hearing, then you can also understand a little bit more of what they were talking about when they were talking about the Bowden evidence and when they were talking about third-party culprit evidence. So when it comes to third-party culprit evidence, what we did hear from the defense team was the following. The autopsy that was performed on John O'Keefe is consistent with him being in a fight, not being hit with the car. That right away seems that he was in a fight with somebody. Now, who could he be in a fight with? Where's the motive? Where's the intent? And where's the opportunity? Well, Brian Higgins had opportunity. He was present. He was close friends with Brian Albert, the homeowner. He had a prior romantic interest in Karen Reed. So there again, we're seeing, and now Karen Reed's obviously with John O'Keefe. Maybe he doesn't know about the arguments or trouble that the relationship is happening, but he's interested in Karen Reed. She did not greet Higgins that night, so it seems that there's some sort of disagreement there between Karen Reed, maybe with John O'Keefe as well, and as with Brian Higgins. Before he leaves, after they left the bar that night, he texts Karen Reed. This is Brian Higgins. He texts Karen Reed, well, ? So a lot of M's after the well, ? And then that's after they leave the bar that night. Now, he also texted John O'Keefe that night after they got to 34 Fairview, trying to, seems, lure him into the house. And at some point, Brian Higgins and Brian Albert were not accounted for in the house at one point, and there was evidence that they were in the basement, which with presumably the argument would be with John O'Keefe killing him. He also lied to the grand jury about calling people. Someone's going to testify that him and Chief Berkowitz were alone with Karen Reed's vehicle when there was no camera activity for a long time. And some of the argument here is that the camera's only motion activated, so that's why it wasn't showing the car. And he also destroyed his phone. So a number of different pieces of evidence that point to Brian Higgins having some motive, having opportunity, maybe intent's a little questionable, but certainly opportunity and enough of a motive to want to kill John O'Keefe. Then he spoke about some other, Colin Albert and Brian Albert, that there was bad blood between them and the O'Keefes, that they would always get into arguments over their going onto John O'Keefe's grass and throwing beer cans on them. And then there's pictures of them hanging out on his lawn when he wasn't there because they knew that he hated that. And he also called Brian Higgins that night, and he never disclosed that. So those are the third-party culprits. Third-party culprits that the defense for Karen Reed is going to be making: Colin Albert, Brian Albert, as well as Brian Higgins. Now, my guess would be that if I had to make a decision on one of them, I would certainly allow in the evidence on Brian Higgins. The question is going to be whether she's going to allow in on Colin Albert and Brian Albert. So that's going to be the question, whether she allows. Has there been enough testimony or enough evidence that shows motive, intent, and opportunity in terms of Brian Albert and Colin Albert? There's been some evidence that Colin Albert wasn't even there at that point, so maybe Colin Albert will be off of the third-party culprit evidence, but maybe Brian Albert will still be there. So this will still has yet to be determined. But I would be surprised if she does not allow in any evidence of a third-party culprit, certainly when it comes to Brian Higgins. And especially as we spoke about, it's a constitutional right, and it was very easily reversible if she makes the wrong decision. So I would imagine that she would err on the side of caution and allow in at least evidence when it comes to Brian Higgins, and maybe we'll see when it comes to Brian Albert and Colin Albert. Well, now you are all caught up on the Karen Reed case. Now you'll be able to view this trial a whole lot differently than you would have without this information. I hope it was helpful. Please, if you haven't yet, subscribe, like, and we will see you next time.